Hello and welcome back to Banking Law Advisor. We're discussing today the case of Japhta. We've discussed it before in summary form, but we're focusing on the limitation analysis here, which is something that can inform limitation analysis done in any other constitutional matter. It's actually quite an interesting subject. Limitation analysis is in terms of 36(1) of the Constitution, which basically means rights contradict each other. To protect one right, you violate another one, and so on. So there's a balancing process to say, is this a reasonable, justifiable limitation of this right? So here in Japhta, we have the situation, you remember, where the people have a debt to various people, small debts, a few £100 in fact. I think it was 200 Rand in one case and 600 in another, but because they couldn't pay them, and the sheriff came and didn't find enough movables to sell, then they actually sold these people's houses to pay for these tiny debts. The Constitutional Court said, no, that's not okay. So the limitation analysis it did in that case of Japhta goes like this. It says, the appellants argue that section 66(1)(a), that's of the Magistrates Court Act, that allows execution on property, in other words, for them to be sold at auction, to the extent that it has the potential of rendering a person homeless, permanently homeless, because of his or her failure to pay a trifling debt. On the test set out above, it's important to note that the fact that a trifling debt can lead to sales and execution is not relevant to the question, so that's not the issue. But it is relevant to the justifiability of the measure. So in other words, what you've got to look at is this a justifiable measure? Is it okay to sell things in execution? Is that justifiable? So what does section 36(1) of the Constitution actually say? And this is key. It's worth learning off by heart if you do these cases a lot. The rights in the Bill of Rights may be limited only in terms of a law of general application. In other words, it's got to be a proper act of parliament or something, or rules. It can't just be the ministers decides that your rights must be limited. It's got to be in terms of a law that applies to everyone. So the rights in the Bill of Rights may be limited only in terms of a law of general application, to the extent that, so the rights can only be limited to the extent that the limitation is reasonable and justifiable in an open and democratic society. So if it's not reasonable and justifiable in an open and democratic society, then your rights can't be limited. An open and democratic society based on human dignity, equality and freedom, taking into account all the relevant factors. Now these 5 factors must always be taken into account when you decide whether a right has been limited justifiably. The nature of the right, that's A. What kind of right is being violated here? In this case, it's housing. B, the importance and purpose of the limitation. So how important is the reason it's being limited? In this case, sales and execution, in terms of the Magistrates Court Act. The importance of the purpose. So the purpose is to sell houses to recover debt. That's the purpose. And how important is that? That's got to be considered. C, the nature and extent of the limitation. So how far is this limitation going? Is it a large limitation or a small one? D, the relation between the limitation and its purpose. And E, less restrictive means to achieve the purpose. So these are the 5 things. And the court says here, of the factors, the nature of the right and the nature and extent of the limitation are of great importance when weighed against the importance of the purpose of the limitation. So we're looking at the right on one hand and the limitation on the other. Now the minister, on the other side from the people whose houses were being sold, has said that the measures are reasonable and justifiable. She says that debt recovery is important. In other words, the purpose of these sales and execution is important. And she says that it's not possible, it's not practical for every execution to be overseen by a magistrate. Yet that was what in fact the court ordered, so they didn't take their point on this. She also argued, the minister also argued, that if the judgment that did in fact happen, that this was declared unconstitutional, went into effect, then people would be more reluctant to lend to poor people because they couldn't take their houses and sell them in execution in order to repay their debts. So that's another thing she argued, as the importance of the limitation of the right, and in other words, the importance that they could carry out their sales and executions. The court also said the importance of access to adequate housing and its link to the inherent dignity of a person has been well emphasised by the court. So we're talking about the right now, the right to adequate housing. In the present matter, access to adequate housing already exists. So in some of the previous cases, it was talking about the dignity of a person in having a house. Relative to homelessness, to have a home one calls one's own, even in the most basic circumstances, can be a most empowering and dignifying human experience, said the court. The impugned provisions, that's the provisions that are being challenged, have the potential of undermining that experience. The provision has taken indigent people who have already benefited from housing subsidies, and worse than placing them at the back of the queue to benefit again from such subsidies, it puts them in a position where they may never again acquire such assistance. So in other words, if these people, they acquired their house with state subsidies, if the house gets repossessed, they can never get state subsidies again. That's the law as it stood at that point. So you're denying them the right of access to housing. And therefore, it is a severe limitation of an important right. So remember, these people's houses are being sold for nothing. Again, I mean, that's another point here. The house is being sold for nothing, which is the case that's coming now, about whether the courts can sell, whether the banks can sell people's houses for much less than the house is actually worth. So it's touched on here. So it's a severe limitation of that person's right that they can't get access to housing again in the same way. So the purpose of the limitation is also important, as the minister contends. However, so in other words, the fact that they can recover debts by selling people's houses, that is important. However, when the focus is on the trifling nature of the debt, the importance of that purpose is diminished. So it's not really as important when the debt's only trifling, the people have the ability to execute to get their debts back. It is difficult to see how the collection of trifling debts in this case can be sufficiently compelling to allow existing access to adequate housing to be totally eradicated, possibly permanently. Especially, and this is where we come to E, 36E, 1E, especially when there's other methods exist to recover the debt. So it's not to say, he says, that every sale and execution to satisfy a trifling debt will be unreasonable and unjustifiable. There are a number of difficulties with such a conclusion. In the first place, it's not easy to adopt a uniform definition of the concept of a trifling debt. What might be trifling to an affluent observer may not be trifling to a poor creditor, reliant on his or her ability to recover debts. So you can't just have a financial limit, any debts below this not, as in fact the applicants asked for in Japhta. Another difficulty is there may be other factors which militate against the finding that execution is unjustifiable. So what he's kind of getting to, which is in fact what the judgment says, is it's not that you can lay down the rules and say this is always wrong and this is always right. The point is judicial supervision, that the court must look at every case and say, well, for this amount of debt, should you really be executing against the house? Should you be selling the houses or not another way? He says the interests of the creditors must not be overlooked. There might be circumstances where, notwithstanding the relatively small amounts of money owed, the creditor's advantage in execution outweigh the harm caused to the debtor. So it might be justifiable to execute. So he's saying, not in every case are we going to ban selling for small debts. Only in some cases. The court must decide on the individual basis each time. Then the minister argued that It's not unconstitutional because the debtor already can come back and ask for it to be reviewed in terms of section 62. But the problem is that most of the debtors are poor and they can't afford to do that. They might not be aware of it, and so the Constitutional Court wants to put in some kind of scheme that applies to everyone. So every time there's an execution, the court looks at it. So that basically is the limitation analysis for in Japhta. So the way, basically what they're doing, if you reduce this to its kind of basics, although, excuse me, this isn't exactly correct in law, but basically you've got the two sides and you've got to balance them together and say which right is more important in this case. So in this case they say, well, yes, you need to execute debts, but if you don't execute debts when the amounts are trifling, it doesn't really affect much the ability of people to execute debts. It's only a few situations where that applies. On the other hand, if you take people's houses from them for trifling debts, you affect that person in a very, very significant way, so you shouldn't be allowed to do this. This outweighs this. And that's basically what the court decided and why they passed the judgment that they did. And the judgment, just in case you haven't got it going through here, basically is that the court must supervise any time that the permission is given to sell your house in execution using an auction or other ways. And that is Japhta and the limitation of rights method. Thank you.